My name is Len Bunton. I'm a construction industry consultant, and I've been involved with the CICV forum since March. I'll be saying a few words about the forum in a minute. For those of you who are viewing this again, our apologies. We ran this session on Tuesday of this week and we had a sound problem, and we decided it was sensible to start afresh. So we're going to go back to the beginning and run all the slides again. Some of you may have participated in the first webinar we ran a fortnight ago on project bank accounts. It was hugely successful. We had about 55 delegates in attendance at that, had very good feedback. You'll find on the CICV forum website a section on project bank accounts, and I urge you to have a look at that because it's crammed full of valuable information as to how project bank accounts actually work in practice. We've also set up a PBA subgroup, and we've drawn into that individuals from all different sectors in the construction industry in Scotland to pool our thoughts and ideas on how project bank accounts can move forward in the construction industry. So please have a look at that. Now, we have 4 other seminars to come in a fortnight's time. We'll be running a seminar on payment issues, which will be run by Professor Rudy Klein and myself, with the other speakers in attendance. And we'll be looking at problem issues in terms of payment and cash flow in the industry. That will then be followed by a session on extension of time and loss and expense claims. We will then deal with suspension of contracts and termination. And we'll finish on a high note in the very last one when we'll be looking at conflict avoidance in the construction industry. You can book these seminars online by just going into the website, so please pick and choose what you want to do. Obviously, we'd like to participate in all of them. Now, this session this morning is on changing the culture in the industry, and by that I mean changing the way the construction industry operates in practice. And our speakers will be talking about contract amendments, negotiating better terms, and problem clauses in contracts. So I'd now like to introduce our 2 speakers this morning. First up on the left, Deborah Harrison. Deborah is General Manager and Legal Counsel to the British Constructional Steelwork Association and spends a lot of her time dealing with queries from member companies throughout the United Kingdom. Our second speaker is Angus Pearson. Angus is a director of Fortis Contracts. He's been involved for the last 35 years in advising employers, contractors and subcontractors on commercial issues, with a particular expertise in the mechanical and electrical sectors. He's been involved in more adjudications than anybody I know as a client advisor. So he has seen the arguments that are run by various parties in these adjudications and usually has been able to find the answer to most of the questions. He's also decided, for reasons best known to himself, to become an adjudicator and currently sits on 4 adjudication panels. So before we start, a few words about the forum. The forum came to life, if I can put it that way, around March of this year when construction sites in Scotland were suspended. And it has brought together all these different organisations, mainly employer organisations. And you'll see there's, sorry, can you go back, please? You'll see there is the Scottish Building Employers Federation, Civil Engineering Contractors Association, the Steelwork Association, SNIPF Select, the RICS, the RIS, et al. So we brought together a really powerful group of organisations. We have gone through 3 phases of the forum. First of all, we dealt with issues concerning the suspension of sites. And then we advised the members on the contractual issues of that. We then had to look at the site startups again and the contractual issues surrounding that. But the biggest phase is the one we're in at the moment, where we're running in parallel with the Scottish Government's Road to Recovery plans, and the people involved in the forum are working hard to try to solve some of the industry problems moving forward. So a few statistics. You'll see there are 23 member organisations involved. I think now we have actually about 120 different individuals drawn from the industry, all working very closely together. And the theme of the forum has been cooperate, collaborate and commit. And commit is the most important thing we're doing, because all of us are committing to changing the construction industry in the United Kingdom. And you will see there that these organisations represent 35,000 operators working in the construction industry. So it's been a phenomenal journey. Both Deborah and Angus are involved in this as well. It's been an incredible journey for all of us, and it's the first real collaboration that we've seen in the construction industry for about 40 to 50 years. So the theme today, thank you, if you just move on to the next one. The thing today is really setting the scene. One of the things that struck me about the forum, ladies and gentlemen, is that everybody was absolutely like-minded that we need to change the way the construction industry operates. The old ways are dead. We need to change our complete thinking throughout the whole procurement process, procurement and delivery. We need to see better behaviour and conduct. We need to see more openness and transparency. And I say to people in my day job, treat people the way you would like to be treated. And we'll be touching in the next seminar on payment on some of the behavioural issues that are not helpful in this industry. Anyway, that's me finished my soapbox talk, and I'm now delighted to introduce Deborah Harrison. Debbie, welcome.
Thank you, Len, for that fantastic introduction. Good morning, everyone. I'm going to briefly refer to some of the current standard form contracts that you'll most commonly come across on projects to set the scene before turning to look at some of the problematic terms and conditions and also how to deal with them in more detail. The JCT and SBCC family of contracts were last updated in 2016. Many of you will be familiar with at least the designer build contract and the designer build subcontract, if not the other forms. It seems to be the most commonly used one at the moment, at least in my experience. The last updates took account of changes in public contracts, CDM regulations, payment provisions, and elements of loss and expense claims, and also introduced performance bonds and provisions for third-party rights and collateral warranties. There are also amendments to the existing structures cover in option C, insurance provisions. Next slide, thank you. The NEC4 suite was released in 2017. New forms of contract were added, such as the possibility of using alliancing and design, build, operate. There were amendments to dispute resolution clauses, cost assessment and final assessments. The possibility was added of using what NEC call undertakings to others or collateral warranties, and that was introduced so you can use them without needing to write bespoke Z clauses. Early contractor involvement clauses were included, and also BIM procedures were introduced. The main forms you'll probably be familiar with on these are the engineering and construction contract and the NEC engineering and construction subcontract, and the various options that you can choose under there. However, it might just be me that I'd say I still see a lot of NEC3 contracts, probably over 50%, I'd say, that come across the table are still based on NEC3. I just wanted to mention, so can you go back one? And that, Angus, thank you. I wanted to mention the standard forms, as we have a specific industry problem here in that standard forms were introduced to simplify and standardise the way we do things across the industry on quite complex projects, I would argue, so that with the idea that you don't need tons of legal advice and input to understand, work on, interpret and administer these contracts. And industry professionals such as yourselves should be comfortable to do that. However, I'd say what has become the standard forms in each case are the standard form set of amendments, standard form precedents that are produced by large commercial law firms with the pages and pages of amendments that ensues. Now, I can see there's room for JCT and NEC terms to be added to sometimes, or you have to refer to certain bespoke agreements that project funders require and other parties require, such as collateral warranties, or refer to certain policies that are in place, or say amplify particular confidentiality requirements. However, that's largely not what happens. There are dozens of pages of amendments which fundamentally change the risk profile of almost every clause, and actually sometimes turn each one on its head to say exactly the opposite of what was intended in the standard form. The outcome is that there's far too much risk in the supply chain, and it sits in the wrong place often, too much on the main contractors, and this then also gets pushed down by default without thought or proper consideration sometimes to the specialist subcontractors and even further down the chain sometimes. The result of a really onerous and risky contract is, I've seen it happen. Parties often just get into a fight from the start. It starts everyone off on the wrong foot and a contentious footing, and then it works against the collaboration and being collaborative rather than antagonistic industry that we're trying to encourage. Now, I realise there are always commercial considerations, and it can be really difficult to step back and to push back and negotiate any contract terms sometimes, but also particularly in a tougher climate where you're under pressure to win work and there's not the steady flow of work coming in. But in my experience, when you do push back knowledgeably and reasonably to the employer or the main contractor, I think this makes your business look more experienced and you know what you're doing with the contracts. And that when the more risky contracts clauses are tackled, the more likely it is that in the ongoing relationship with your employer or main contractor, these clauses won't be put on the table in the first place. So I'm now going to look at some specific problem areas and how to approach them. Next slide, please. Thank you. Liquidated damages. Sometimes these are referred to as liquidated and ascertained damages. It's the same thing. I think that's a JCT specific term. They're the sum agreed by the parties, which is in advance, which is payable, usually in the event of delay for when the contractor is not entitled to an extension of time. There should be a start date for the LDs, either at completion or when practical completion should have occurred. But particularly be careful with key dates and sectional completion, particularly key dates because they can just be included in the schedule of amendments and you have to read it carefully because they can mean that if one milestone is not met, then the LDs can kick in at that point and there may be different LDs for different key dates or sections. They must be a genuine pre-estimate of loss, which will be caused to the employer if the delay occurs. So it can't be a penalty clause, and the courts have held that if the agreed sum would be extravagant and unconscionable compared with the greatest loss that could flow from the breach, that would be a penalty. The clause will also be a penalty, deemed a penalty clause, if the detriment it imposes on the defaulting party is out of all proportion to the legitimate interest the innocent party had in the fulfilment of the original primary obligations under the contract. Simply punishing the defaulting party was insufficient, held to be insufficient to amount to a legitimate interest. But it's vital to appreciate that LDs constitute the amount, no more and no less, that the employer may recover in event of a delay. He's not required to prove that he's actually suffered any damage at that point, simply that the contractor is in delay and is not entitled to an extension of time. However, on the other side, if the actual loss exceeds the agreed amount of liquidated damages, he may not recover the balance. the principal may want to claim a greater amount for general damages in this case, so say loss of enjoyment, stress and financial pressure. The case law makes it clear that where positive sum of LDs has been stipulated, then this will weigh heavily in favour of a finding that the LDs clause has provided an exhaustive remedy for the contractor's delay. I've had a pre-submitted question on this, which kind of feeds in nicely to this topic. We have a subcontract value of about 100k on a 20 million contract. Damages at 50k a week are completely disproportionate. What can we do? Well, I would say it is totally out of proportion. You might be able to argue that that is a penalty. And on the other side, I can see from the main contract perspective, one contractor can cause a delay to the whole project. But you've got to think about going out and getting competitive quotes as well. And, you know, seriously, you're not going to get very competitive quotes with such an onerous term in there. So, yeah, definitely push back on that one. Next slide, please. And just to say, the way to deal with LDs is to have a commercial discussion about capping them, either to an overall financial limit or in time, to say a number of weeks. And on to design responsibility, another thorny topic. In a design and build situation, you may have many parties on the project who are doing design work. These may be the architect, the structural engineer, M&E engineering consultant, main contractor and specialist subcontractors. Under a JCT or SBCC, it says the contractor is responsible for designs under the contractor's proposals. However, this is usually amended to say the contractor takes responsibility for the employer's requirements, so the design is prepared by the employer's design team. This may be okay for a main contractor where the design team will be novated across to the main contractor when they enter into the main contract. And that's done so as if they've been working for the main contractor from the start. So then the main contractor has direct recourse to the architect, structural engineer and M&E consultant if anything goes wrong. You should look out for this amendment, these sets of amendments in the recitals, articles of agreement, and also in the consequential amendments to the clauses on who takes the hit for discrepancies and divergences. So in particular, clause 2.1 and then 210 to 217 in Design and Build 2016. I just want to talk about this further in terms of subcontract amendments. One example, 2.82 of JCT subcontract, Design and Build subcontract 2016, says that subject to clause 212, which is the clause that deals with divergences from statutory requirements, the subcontractor shall not be responsible for the contents of the contractor's requirements or for verifying the adequacy of any design contained within them. This is often amended to say the exact opposite. I would argue that the position of the main contractor and the subcontractor are totally different in this regard. As I mentioned earlier, the main contractor is likely to have a direct contractual recourse to the design team. The subcontractor doesn't, yet are still being asked to take responsibility for someone else's designs. There's also a timing issue, particularly with subcontracts. Sometimes subcontracts are let and documents sent out in pretty short order, and there's no time for the subcontractor then to even check the designs, let alone take responsibility for them. So it's a big risk for them in terms of extra time and cost, and I would suggest that these amendments should generally be resisted. Next slide, please. Now we're moving on to a specific area of design responsibility, the CDP, contractor's designed portion. This is associated with JCT and SBCC construction contracts. It's an agreement for the contractor to design specific parts of the works. The contractor may then in turn subcontract this design work to specialist subcontractors. It should not be confused with design and build contracts where the contractor is appointed to design the whole of the works. Under the latest standard building contract, the CDP is no longer a supplement but is incorporated into the main contract, but a separate subcontractor design agreement is available where the main contractor is to design specific parts of the works and a subcontractor is to design part or all of the subcontract works. So with design responsibility, well, with any of the clauses, to be honest, it's a case of reading the contract from front to back to determine where the design responsibility sits. I find it's an area that can often be unclear and can be written down anywhere from a single line on the front page of a subcontract order to a full development in the employer's requirements. It can be even more of an issue with digital-only contracts. I just wanted to touch on those because you don't often have any printed documents to read through for a pen and ink signature. And you really have to make sure you've got all the documents that are referenced within. I've got another pre-submitted question which fits in quite nicely here on CDPs. In relation to CDPs, the interface is always a problem. Who's responsible for that? Usually the main contractor is responsible for the interface and for ensuring that specialist subcontractors under its control coordinate their emerging designs with one another. Often a design manager will be appointed in the main contractor to deal with that. I do often see this coordination responsibility, however, passed down to subcontractors in subcontracts, which I think is a bit of a mistake, and it could just be a copy and paste from the main contract. I think it's fair and reasonable to ask all the specialists to cooperate with one another on site, but a bit ridiculous to ask them to talk amongst themselves and coordinate the works. And I think you're opening yourselves up to potential disputes and delay. Next slide, please. Now I'm turning to look at third-party agreements. And by third-party agreements, I don't mean third-party rights and collateral warranties. I mean other ancillary documents which have been agreed between the main client and third parties, such as a funder, bank, local authority, or landlord. The examples are finance agreements, development agreement, or an agreement for lease. There are a couple of examples of the types of clauses that you might see in the first bullet point. And I've got a pre-submitted question again, which fits in quite nicely with the second bullet point. Most tender documents say that we have to be aware of the main contract conditions. What happens if we don't examine these due to time pressures? Well, first of all, are the main contract conditions properly incorporated is one thing you have to say to yourself. And I'm really speaking to a subcontractor audience on this one. But think about how practical it is, especially in these times, to actually go over to someone's offices to inspect a document or have someone come into your offices to inspect a document. If there is a clause properly incorporating the main contract conditions, and there's a clause making you responsible for causing the main contractor to breach the obligations in the main contract, you could be exposing yourself as a subcontractor to increased obligations and liabilities you might not even be aware of if you haven't had a chance to read them. For main contractors, it may be more reasonable to have certain obligations from third-party agreements I mentioned included in your obligations under the main contract, but it's a question of timing. How long have you had to read and understand these agreements? Always read the definitions first and tick off whether you've received all of these documents. I can see why drafting is done this way to tie everybody in and make sure there are no loopholes from a legal perspective. But I'd say it's a slightly unclear, a bit lazy, to be honest, and underhand way of doing things at times. Far better would be if we could have a situation where all the obligations are written clearly on the face of the operative document. And These clauses, I would say, become less and less reasonable the further you get from the parties who originally negotiated the documents, and the further down the supply chain, and the smaller the value of the subcontract, and the timescale in receiving the contract documents before you're required to sign them. The way to deal with these clauses, there's several options. Delete them entirely if you can, or limit them in time. Documents provided before a certain date, ideally before we've fixed the price of the contract sum as far as possible. Then if the documents are provided later and confer additional obligations, these are then treated as a variation. Or refer to extracts of third-party agreements, make the other side do the work, pull out particular pages or sections very specific to the works or the subcontract works which apply. And better still, say that those extracts have to be attached to a particular schedule, Schedule B, etc., and certainly not to be inspected at offices. I think we should move, though, towards plainer drafting and obligations, and the obligations all being contained in one agreement as far as possible. And I think insurers would thank us for that as well when it comes to your professional indemnity. Next slide, please. So the next slide is on indemnities, and the first bullet point is an example of the type of clause you might get under a contract, but also just look out for the word, perhaps you can do a word search if it's on screen, just look out for the word indemnity, indemnify generally, and see how it's used. If you're going to accept these clauses, you're potentially extending your limitation period to when a claim can be brought. Under case law, it was held that an indemnity clause did not give rise to a cause of action until its consequences were ascertained. Therefore, in the particular case, it was not until a claim was made by the main contractor in respect of negligence by the subcontractor that the indemnity clause operated and time began to run on that particular clause. The party claiming on the indemnity is not required to mitigate loss, as you would usually be required to do under a damages claim. They can be sometimes useful for a specific risk that would generally exceed the general liability cap. But generally, I would say to be avoided if possible. They can be quite tricky to deal with. If you can use some wording, instead of saying indemnify, the party acknowledges it may be liable to the other party for something under another contract, perhaps. But then you can also put in a requirement to the other party to mitigate losses, or the losses have to be direct, and it sort of gradually walls it down. And you can also do something with an overarching limitation of liability clause as well, which I will discuss shortly. Next slide, please. So the next slide is on cross-contract set-off. This is where the employer may choose to set off amounts they say are owing to them under other contracts they may have, and against any amount owed to you under the current contract. And there's an example of one there. The problem is there's often a wide discretion for the employer to say there's a problem under the other contract, which you may well dispute. They might say there's a defect and you say there isn't, but it's just on their say-so, and it's giving them another excuse not to pay or to withhold part of payment. I think the way to tackle these, and I suggest they're just struck out altogether, is that they're contrary to the Construction Act. Section 110 says that payments can be only linked to matters within the current contract. I mean, that's meant to deal with pay when certified issues and receiving certificates of practical completion before payment and so on. But I'd say you can extend it to argue that it's contrary to the Construction Act to have a cross-contract set-off. Payments cannot be conditional on a decision by any other person as to whether obligations on another contract have been performed. And the next slide, please. And my final clause we'll be going to look at is limitation on liability. Always do limit your liability if possible, because the implication of not limiting your liability is open-ended. If you have a PI clause in there, that's just saying how much PI insurance you have to maintain. It doesn't necessarily limit your liability without having a separate clause in there. I just mentioned that because the two things are often confused. You can have a cap on liquidated damages. I mentioned how to do that earlier, or an overall cap on general damages. And there's various inner things you can do on that and cap different areas. And you can have an aggregate cap, which is a total of the claims, or it's a level of insurance to something each and every claim. You can try and exclude consequential loss. Consequential loss or indirect loss arises from a special circumstance of the case, not in the usual course of things, and it's recoverable only if the paying party knew or should have known of that circumstance when it made the contract. Although under a construction contract, what the party may have known about that can actually be quite wide. It potentially doesn't limit that much, but I would say it should be used where possible alongside other limitations. So it has the effect of limiting the potential claims against you. Net contribution is a possibility, though very difficult to negotiate these days. Net contribution clause is a common feature of the residential and commercial property development sector, the construction engineering industry, but it's one of the most debated provisions during negotiation of contracts. It reverses the common law position of joint and several liability and limits the defaulting party's potential liability to the innocent party in situations where more than one person is responsible for the innocent party's loss. Quite difficult to get those clauses in, and certainly in my experience, banks, funders never accept them. And if you can't limit your liability within the main contract, within the main contract or subcontract, the main document you're entering into, try and limit your liability in collateral warranties and third-party rights. So at least you're limiting your liability to other parties. And that's the end of my bit, and I'm going to pass over to Angus.
Thanks for that, Deborah. Some very helpful and insightful information there, which I'm sure everybody really appreciates. Good morning from me, although being a recording, it could be whatever time of the day, wherever you are. Some of you are probably sat in your pajamas. I'm going to talk to you about some of the typical banana skin clauses you may find within contracts and subcontracts to help you identify and perhaps negotiate. I fully endorse exactly what Len said at the introduction, that there needs to be culture change across the industry. We need to find more equitable ways of working together, more collaboration, less risk dumping, and working together for a better future for the industry. There's too much acrimony, dispute, onerous contract conditions. So the first thing I'm going to touch on is Glenn mentioned earlier, he and Professor Rudy Klein will be giving a detailed seminar on payment and payment provisions within contracts and what you can do when you're not being paid. So that will be very helpful to the majority of the people that would view these webinars, and I'd strongly encourage you to tune in for that one. I'm just going to touch on the essential ingredients for a construction contract to be legislatively compliant. So what do I mean there? Well, within the payment terms, every construction contract has to have a due date for payment and a final payment date. What's the difference? Well, the due date is the date upon which a sum which is certified becomes payable, certified or notified, in which it becomes payable to the payee. It does not mean the date that it must be paid. That would be the final date for payment. So we have those two dates. So if you think in the due date as when a sum falls payable, and the final date for payment is the date by which that payment must be made by the paying party. It's important that your contract has both of those dates. Quite often your applications will relate to due dates and things like that. So you should always read your contract thoroughly, make sure that you understand when your payments cycles are, when, and always be aware of these so that you can chase up certificates or payments or issue notices if you are not receiving those requisite things. Where contracts do not comply with the terms of the Construction Act and the later amendments, there's a very helpful piece of legislation called the Scheme for Construction Contracts Regulations 1998, which was amended in 2011. That can be implied into contracts that are deficient. So if you don't have a due date or a final date for payment, or the means of determining what amount is due, then that document can be applied to patch up and repair the broken clauses. So it's a very helpful piece of legislation there. So you've read your contract, hopefully. You've identified what the payment cycles are. Ideally, you have them in a schedule of dates, which just makes it nice and clear, and anybody responsible for applications and certifying should have a little table of these things close to hand. Quite often you see in contracts, there's a due date at clause 11.2 and at clause 99.7, it tells you when the final date for payment is. And at clause 74.3.1.2, it tells you that your application has to be in 5 days before the due date. So knitting those things together, the best way of doing it and the clearest way is to put them in a schedule. Can't stress enough the importance of you being aware of your due and final dates and complying with those. So something that we see, just moving on to more prescriptive requirements now for applications. So not only must you submit by the requisite dates in your contract or subcontract, you tend to find now that there may be a prescribed format that has to be in this particular shape of application. It must be called by a particular terminology, whether it be an interim application, final application, a payment application, a stage payment application. Again, clarity is important in these things. Call your application exactly what it says in your contract. That way there's no scope for ambiguity or anything like that. Make sure that it's issued or served by the prescribed means in the contract. Some places, PEs will not accept applications by email. Again, I would urge people to negotiate those terms early on so the email applications are acceptable. It's a good way of making sure that things are in on time and they're traceable and easy to follow up. The content, you may find that applications require you to provide substantiation for every variation or every sum claimed. Now, the risk, if you don't comply with the application requirements, both in terms of the time and method and content of is invalid, and you may have no right to payment if you don't comply with what the contract says. Again, if you think it's overkill, the term been asked to comply with just for a payment application, negotiate with the other side and say, I'd like to submit by email. Here's our usual application format. Are you happy with that? Get an agreement in place. The other important thing, beware of the fluid program. Quite often you'll see the words as per main contract program or construction program or something like that. Or worse still, TBA, to be agreed. You need to have finite timescales within your contract. Everybody has to know when you're starting, because as Deborah touched on with the damages, you need to know when these start potentially. You need to know the basis of time that you're engaged to complete your works under, so that you can adequately include your prelims costs and things like that. It's important. If it's left hanging out there, and we see this in the world of disputes all the time, when do damages start? When is that contractor in delay? You say I'm in delay, but with no agreed program, it just creates all sorts of difficulties. So agree a timescale. If not a program, at least make sure you've got the duration of your contract agreed. It keeps everybody right from the start. Don't leave it open. Sometimes good to even include these things at pre-start meeting stage, because pre-start minutes are usually incorporated within a contract when it gets through to completion of it. Another clause that I'd say keep your eye open for is termination for convenience. So where you've put the time and effort into pricing, really winning, negotiating and agreeing, or a main contractor or someone further up the chain has the right to determine your contract for convenience, for any reason they should require. And if that clause is in there with no financial implications attached to it, then you're very much exposed to under recovery and costs and such like. Worst case scenario, let's say a main contractor dealing with a subcontractor, another subcontractor comes along who's much cheaper. You know what? We can just terminate your contract and we'll go to the cheaper guy. So it's one to watch out for. Don't particularly see it all that often in subcontracts, but they do pop up now and again. So again, taking Deborah's advice, a little word search for convenience might flag up something like that. The equivalent almost of this is the right to omit works without any financial consequence. So in a similar scenario, without having to actually go as far as determine someone's contract, in other words, the obligations that you've performed up until that point in time would still survive if the remaining part of your scope was omitted. So let's just say you had £1 million worth of work remaining to do under a contract, and you receive an instruction saying, we're omitting that with no financial consequences to termination of your contract, but with the added benefit to the employer or main contractor that your obligations up to that point survive, and you don't end up with any arguments about wrongful termination and such like. So where you see that clause, I would say, you know, negotiate that it should be valued in accordance with the variations mechanism. In other words, there should be some, if you want to omit that volume of work from our contract, then we want compensated for the bit that we're going to lose out on. Again, very important. There was a case came down in Scotland just this week that's a timely reminder. Van Oord and Dragados. There was an opinion from the court about what you can do in terms of omission and whether or not that is a breach or whether it becomes a variation. So it's worth a read for those of you that are really obsessed about this type of thing. An important right that should exist within your subcontract or main contract is for you to have the right to claim for delay and the compensation and financial consequences arising from that delay if it's caused by someone else. So if it's caused by the employer, a main contractor, or other subcontractor that effectively prevents or delays you from completing your works within those planned time scales that you've agreed and got into the contract, don't forget. Claim for the delay in such a way that it gives you relief from any damages. In other words, if you're going to finish late, the clock doesn't start ticking on when you start paying the liquidated damages that Deborah spoke about. So the first aspect of it is relief. The second aspect of it is there a way by which I can get compensation under this contract if someone else delays me? Quite often, particularly in subcontracts, you'll see them amended in such a way that you may only get an extension of time as a main contractor gets under the main contract. Well, what happens if the delay event is caused by another subcontractor? Now, you can bet the main contractor is going to be charging the subcontractor damages and compensation, but some of that ought to be paid out to other contractors that have incurred costs. So it's important, make sure that you've got that mechanism in there. We would usually ask for extension of time with fair and reasonable compensation. Just makes you whole again, reduces the risk. You don't want to be carrying the can knowing that you could be delayed for an inordinate period of time without any kind of compensation, particularly when it's not been anything to do with you, your company, or personnel, or anything like that. The pay when paid provisions that Deborah touched on, and again, Len and Rudy will go into this in a bit more detail in the payment seminar. The one notable exception is in the event of insolvency of an upstream paying party. So if it was a developer or let's just say a main contractor, if you're a subcontractor, it's the one exception. If a paying party becomes insolvent somewhere further up the line, the party that you're in contract with, provided that they've written it into the contract, may be absorbed. Why is this important? Well, you have to think when you're doing your diligence and you're going into contract, if you're a subcontractor, there are 3 parties above you that you have to be persuaded are solvent and robust enough to see this project through. Because if any one of them were to become insolvent, another needn't pay you. So it's not just that you're in contract with the next guy and regardless of what happens, you'll be getting paid provided that your employer survives. You have to be aware of those risks and that there is a way out of paying you where those provisions are written into your contract. You'll often hear people arguing that we don't have to pay you because the developer or whoever went pop. It's only where it's written into your contract. It's not an automatic right. It's not something that's in the legislation or anything like that. So where that provision is there, do your diligence and understand who it is. Deborah touched on the main contract conditions. Again, you'll very rarely factor. You might get thrown a CD or a Dropbox link to a 3 million page document. What we would encourage clients and subcontractors to do is, if you've not got access to the documents or they're not adequately incorporated, ask the employer or main contractor which particular terms is it you want us to comply with. can we see these? Let's have a look at it and get it out there and clarified, so there's no ambiguity and things falling between the various stools. Deborah touched on it with the design obligations and how they're often turned on their head when it comes to main contract and subcontract. A good way of resolving that particular issue, I find, is to include a design obligation matrix, so that there's a clear delineation between the obligations of the various parties, quite often incorporated, just to bring a bit of clarity to that issue. So beware the main contract conditions, try and get them narrowed down where you can to only those that affect your particular aspect of the contract, because there's often a tension between main contract and subcontract clauses. Another important part is an entire agreement clause. This usually means that the documents that you have incorporated in your subcontract, your numbered documents or subcontract documents, are the only documents that form your contract. That can often be at the exclusion of your tender offer or your bid or whatever it is you've put forward, where you may have your own qualifications, terms, different design proposals and such like. So where you have an entire agreement clause and you have particular qualifications or perhaps derogations to the specification and such like, you must make sure that those qualifications and changes you require are incorporated. Quite often done by a simple schedule saying we require, instead of a type A fitting, it's going to be type B. You've agreed to that. That way part of the contract that has been agreed to, it's in there, and you're no longer able to rely on your tender, your quotation, all the rest of it. So use the opportunity, perhaps again the pre-start, to get your schedule of clarifications or qualifications incorporated. Another important one is, which I doubt if you would ever have any success negotiating this one out, it's the non-waiver clause. What it means is that both parties usually, particularly the employer under the contract or the main contractor under a subcontractor, has the right to rely on any term of the contract at any time. So you cannot later rely on an established course of business, where happens a lot around payment applications. They may not have been in the exact format that the contract prescribes. You could be a day late and you've still been paid and things like that. When push comes to shove, the employer or the contractor can rely on any of the exact wording or any term of the contract at any time. So they're not conceding or waiving any of their rights under the contract by relaxing things as you go through the contract. So don't get too cozy where you may not be performing your obligations in strict accordance with the contract and it looks like the party you're in contract with is accepting that. A non-waiver clause means that you have to stick to those terms. And as I said, I doubt if you get it negotiated out. Why would anybody? All they're asking you to do is comply with the terms that you are agreeing. A little additional thing here is, obviously in these times of COVID, we've seen one or two COVID clauses appear within contracts. And I just want to touch on those. The position generally is that most employers and contractors will accept it as a cost-neutral delay event where there are shutdowns and such like. So particularly where the government has stepped in and is paying something under the furlough scheme. So contractors needn't be, as lawyers need to acknowledge and recognise that, yep, the project's going to be late. These are extraordinary times, and personally, I would rather see the COVID clauses just termed an epidemic or pandemic clause, so that it sits there in contracts forevermore, so that whether it be COVID-19, COVID-20, or some other pandemic that comes up in the future, we should have that accommodated within contracts. We should all learn from this. So, moving on, I can't reiterate enough the importance of reading your contracts, particularly understanding your payment obligations, your payment terms, when your cycles are, what damages are you exposed to, and can you put a cap on those? What are your timescales for doing the job? These are the fundamentals. If you can get those agreed and you're happy with it, crack on. If you're unsure, try and renegotiate the terms. If there's wording in there that you don't like, why not take a bit of advice? But make sure you don't start the work until you've got agreed terms. Quite often you'll find that you get a hearty contract or subcontract issued to you 2 days before, right? Start on Wednesday, and you've very little time to review those terms and conditions. And as a legal principle that's known as the last shot, you could be deemed to accept those terms by your conduct in starting the work on site. So if your terms and conditions, yes, we will start on Wednesday, but it's on the basis of our quotation and the understanding that terms are still to be agreed. Put something in place, then go back and renegotiate the terms you're not happy with. Put them in, most often, a little schedule or a letter or something like that. Make it easy for the other side to accept, so that there's only one other document maybe incorporated within the document. Keeps it easy. It just helps you highlight and manage the risks. Some clauses you may have succeeded in getting diluted down the way, more equitable to you. Others you haven't. At least then you know that's still a risk to my business, and I need to manage that out the best I can. The last solution, if you like, the last resort, is to walk away. That's a courageous thing, given the economic climate we find ourselves in. But you have to ask yourself, as a responsible business, am I prepared to shoulder this inordinate risk? Am I prepared to take a hit on pricing and draconian terms? Should I steer my business in this direction as a officer of a company? You need to think about these things. And if the answer is no, then don't be tempted by just the pound signs at the bottom line. You have to weigh that up in consideration of the risks, obligations, and liabilities that are under that contract. And again, if you're not sure about these things, there's plenty of good people out there that will help give you advice. Turn to your trade bodies. There's usually assistance for this type of thing there. So that's really all that I can say on the banana skin clauses, but the things that you need to look out for and try and negotiate more equitable terms. I'm going to open up for questions now, which I think Len has taken some during the live session, and we'll ask Len to put those out just now. So thanks for bearing with us, and over to you, Len.
Thank you. Just before I do that, I just want to mention a couple of comments, particularly from the perception of an adjudicator. First of all, please make sure you're using the current editions of the SBCC contracts, the 2016 editions, which have got subcontracts documents as well in the family and subcontracts. I'm still seeing parties referring matters to adjudication using the 2011 edition. And I've mentioned before, I had an adjudication last year, minor works form 2006, which is completely out of date. So, you know, get up to speed, make sure you've got that information. The SBCC website has got a wealth of information and you can get these documents digitally. So that was point one. Point two, contract amendments. This is something that the forum has been in discussion with the Scottish Government. And if you look at the Scottish procurement guidelines, they make it clear in one of the documents that the standard contract should only be amended under exceptional circumstances. Now, we fought long and hard actually to get that wording removed, because I do not consider that standard contracts need any amendment. Bear in mind that these contracts are put together by representative organisations throughout the industry, and they really are the amalgam of the best that we're going to get. So I'm anti-contract amendments. What the Scottish Government has now come up with in the last CPN Construction Policy Note was to say quite firmly, please don't amend contracts. But if you are going to amend them, then what to do is do that in track changes so that contractors and subcontractors tendering can see what the additional risks and obligations that they're taking on. The last thing you need to get is 20 pages of amendments. Piling your way through these, sometimes it takes days, and frankly, you lose the will to live. So the easiest solution is to show the contractors the track changes. Gus mentioned COVID clauses. We've seen recently from 4 different Scottish local authorities the different ways they're treating COVID clauses. And the most equitable one has been from a council, where they've now said that they've defined what COVID is. They're saying it's a relevant event and it's a relevant matter, so the contractor gets time and money. And again, we're in discussions with the Scottish Government about trying to get the authorities onto an even keel with these COVID clauses. The 2 things I wanted to ask our speakers to comment on, and it relates to a question from a subcontractor who said we quite often get batted back on a variation because the architect or the employer or the quantity surveyor says, what you're claiming is design development. Now, in my experience, it's very seldom is that actually defined in a contract as to what design development is. And it seems to me it's just a bottomless pit that people chuck an argument into. Debbie, the steelwork contractors must face that type of issue, I would imagine.
Yes, absolutely. I do get questions from members where it goes back to design responsibility and making that absolutely clear in the definitions. And sometimes it's very difficult, even for me, to read through and work out what they're supposed to be designing and what falls to someone else. And obviously, my members have got, most of them do design small amounts or large amounts. From the bolt strap down to the the whole steel frame for the project or the bridge, but yeah, it's just got to be very clear, I think, under the contract. And if you're not sure what you're designing, it's the first question, one of the first questions you'd be going back and asking, what we've discussed in the meeting doesn't seem to be reflected here, or what I've put in my tender doesn't seem to have come across in the document. So I think it's a question of clarity and of design responsibility, making sure everyone's absolutely clear on that, or including a matrix as Gus suggested. It's a good way of doing it.
Yeah. I'd like just to mention this point. We had an discussion. Sorry. We had an interesting discussion recently with a Scottish local authority who said that they felt that the industry would benefit from workshops between the contractor and the design team and the employer before a contract is let, so that you can spend a whole day identifying the key issues in a project and either designing these out or providing provisional sums or something else, so that when the job starts, you've more or less got rid of all the uncertainty over design and construction issues. So I think that's a good idea that the industry will take up. It's something the forum is looking at, actually drafting protocols.
I think that's a
Gus,
very good idea.
Yeah, Gus, have you got anything to say on design development before we move on?
Yeah, couple of things. We talk about defining it. And now I'm asking my experience. I have actually seen design development defined at the front of a contract in the following. Design development shall mean development of the design. Now, that's not particularly helpful to anybody. And I've also seen it defined as any changes to the any material changes to the design. And you think, well, what on earth is a material change? So it's no less clear or well defined. Early contractor engagement, a design matrix, the more certain your design is at the stage of going into contract, the better. It's going to reduce, let's say, the likelihood of debate on design development. For some specialist systems, it is a necessary evil. It's only when you get to a certain stage of the project being complete that you can understand which particular aspects you are going to have to accommodate within, let's call it, back-end design. But we should all be striving.
Yeah. Another thing I want to mention, just go back to what Debbie mentioned about contractor design portions. I think that's a huge problem area for the industry. I'm convinced it's been driven by the drive down in professional fees of designers, where they've simply said, well, these are elements of the building that we are not prepared to design. Last year, I looked at a project that had 36 CDP packages in it. And in one instance, one CD package affected another 6. And without a word of exaggeration, I came across a communication from the architect that was circulated to 46 different people in the design team, the main contractor, the supply chain, all who had to input into the resolution of a design problem on CDP. And again, for any consultants listening to this conversation, it's critical, I think, at the start of the contract or before the contract's let, to sit down and go through these contractor design packages and thrash out any issues. Again, anecdotally, last year I was involved in an adjudicator in a fairly fancy building. It was a V-shaped plan, and in the center of the V there was a massive canopy. It's the sort of thing that you see when you go into a garage showroom. And the contractor had to design the canopy, but there was no design information at all as to how the canopy fitted into the other parts of the building. It ended up in a very complex and costly adjudication. Now, that sort of thing should be eliminated prior to the contract starting on site. So I think if there's any message from us to you folks that are getting involved in building projects, is to pay a lot more attention to that type of thing, either at the design stage or before the contract is let. Now, one question that's come in, I'll read the 3 parts. How do we make main contractors collaborate with their supply chain? Do you consider that COVID-19 could be a driver for positive change within the industry? And how do we start the change process? So I'm going to pass that over to, first of all, to Gus. How do we make main contractors collaborate with their supply chain?
You can't make anybody do anything. You can obviously incentivize behaviors, let's say, and it comes from employers down. You know, contractors are under enormous pressure to make money. They've been driven, the prices for tendered works has been driven down all the time, and we could find ourselves heading into another race to the bottom that we find at the end of any recessions and such like. We've all been through the pain and the grief of this before. As I say, there's nothing you can perhaps do. You can maybe legislate for better payment terms, put that into public contracts, monitor it and police it to make sure that the supply chain have been treated more equitably. Obviously, project bank accounts is a very helpful webinar that Len and Rudy have produced on that. That's a positive change that will encourage better behaviours. But quite often, I tend to find that the more successful contractors in difficult times are those that are prepared to sit and collaborate and buddy up with their key suppliers and subcontractors and say, right, we're all in this, we're targeting this project, we win it, you'll win. Instead of always going out to the lowest guy and hawking about other people's prices and things like that. There's a couple of tier one contractors that have nurtured very good, healthy, successful relationships with the supply chain, and that's been a benefit to them. And it goes all the way, percolates all the way down the supply chain. So better engagement and perhaps a bit more openness and trust, as you spoke about, Len, at the start of this. The adversarial days and just trying to screw people down on price going into a contract and then do the same at the back end when they're coming out with slashing variations that you've paid previously and then dreaming up contra charges, all the rest of it. It has to become a thing of the past. And it's all about encouraging behavioural change. That's all I can really say to that.
Deborah, one for you. We've all been in the forum ship, all rowing in the one direction for the first time in 50 years. Do you think COVID-19 will be a driver for change in the industry?
I hope so. I think it has to be. We seem to be, I think we were having a discussion, however, on a more pessimistic note, probably 25 years ago or more, you know, the industry needs to change. And I think it has since then. It's not the same. But in terms of COVID, we do have to all pull together and it could go the other way. I mean, it could be a race to the bottom in terms of prices, and it could easily make things worse. And I think we have to work together now as an industry to make sure it doesn't. We've had Grenfell Tower and the conclusions of the report, and everything comes out of there. We have to improve skills, standards, safety at the same time, which is not easy. But as you say, things like design workshops, getting specialists involved early, I think is absolutely key. And from the client side, there has to be, you know, realistic timing on projects to allow that not to be the huge rush to get spades in the ground and get going, and to get the design fixed before you start as much as possible, and to get everyone involved, talking to one another. And it's about good communication at the end of the day, and not pointing fingers and having a blame culture where possible. But it comes from all sides. It can't just be done by main contractors. It can't just be done by specialists. And a lot of it has to come from the clients as well. And that's where government can help as well, being a good client, both Scottish Government and any of the devolved administrations, and from Westminster and any public sector body, be the best client and to show a good example for the rest of the industry.
Yeah. Okay, well, we'll draw to a close there, ladies and gentlemen. We're just about bang on time of an hour. Thank you very much to our two speakers for their excellent presentations, and for colleagues, communication people in the forum who put these sessions together. Just a reminder, 13th of October, 11 o'clock, it will be fireworks. Rudy Klein and I will be arm wrestling and fighting on a number of issues. I hope you can tune in and enjoy that. So we'll sign off now, and thank you very much for your attendance, and hope you enjoyed the webinar. Thank you.
Thank you.
Thank you.